Garima, you can begin.
Yes. A warm good afternoon to everyone. I, Garima Shukla, member of EML committee and moderator of the session, presenting on the behalf of Department of Law, Prestige Institute of Management and Research, Indore, would like to welcome again Dr. Hardik H. Parekh, sir, respected faculties, and all dear students. So, in continuation of yesterday's session, we will start today's session. So, I request sir to please kindly take over the session. Thank you so much.
Thank you so much, Garima, for a great introduction and beginning the second session. So, good afternoon to everyone. I hope I am audible and visible to everyone. Let us continue the journey further. So, yesterday we started the discussion on the basics of property. Let us keep in mind that the topic which we are discussing is worthy to be written or described in an entire book. That's a huge length of the topic is available, right? So the topic is such a wide that you can discuss it in a series of classes, but we are taking certain important historical events and we are trying to understand that what actual changes have been brought and what is the current status of right to property under Indian constitutional regime right now. And that's why we have started the basics of the property. Yesterday we discussed that how the property is very important concept, how does property management is important for a country, and more particularly the country like India, which is newly have achieved independence, and there is a great difference of ruling structure. Some of the princely states are available, some of the British domain provinces are available, and in light of that, how the government will take a control on the property, because the government is always required property for two things. Number one, that they want to have a development, that the country have to have certain kind of the basic infrastructures. Number two, about the management, that what is actual holding land as well as building, how it should be properly managed. And for these two purposes, Indian constitution has already given an inbuilt mandate under the directive principles of the state policy. I'm sure the students might have referred this principle. You can refer article 36 to 51, and then it is followed by fundamental duties, article 51A onwards. So when you read directive principles in fundamental right, both of them together, you will find out that state shall, the word state has been used twice. The word has been referred, one in article 12, where the fundamental rights are referred and who is supposed to protect those fundamental rights. And number two, in directive principles also in article 36, you will find out that state as well as 36, 37, both articles are giving, and 38 onwards, the directive principles are starting. In order to use this all provisions very properly, effectively implement, the state governments and union governments started implementing. So we saw that the land reform legislation's role came, a first primary task when it is simply, you can understand that when you when you shift your residential premises and when you take a new home, and if everything is haphazardly organized there, the first task or first priority would be you will organize everything. So you will manage the things properly, you will arrange all the things at a particular place, and then you will try to see that how the new mechanisms can be developed. The same thing happened in our country, and accordingly, a lot of government, including the central government as well as various state government, enacted the land reform legislation. Okay, and this land reform legislation directly came to the conclusion of particular item. Just 1 minute. I'm okay, I'm sorry for disturbance. The phone was constantly ringing, so I had to switch it off. Okay, so in that way, the land reform legislation came, and the first ever case we discussed in form of the Kameshwar Singh, the Maharaja Dhiraj Kameshwar Singh of Dhanbad. That was a particular citation, and we discussed that how Bihar Land Reform Act challenged in this particular case. The act was providing for the taking of the management and then paying the compensation to the landholders, but then the uneven pattern of the compensation was observed objectionable by High Court, and then it was affirmed by the Supreme Court also. And then we saw that the particular case become a very important landmark judgment, because of this judgment, all the country nationwide program have certain kind of the quote unquote threats, and that is why the answer of this particular judgment was given by the Parliament by enactment or introducing the first ever amendment into Indian Constitution. And that's how we could see that Article 31A and 31B came into picture. Along with Article 31B, the schedule number 9 also got inserted. So that was the discussion which we have made till yesterday's class. Now we'll move forward and you will enjoy certain other interesting development which have taken place after that. So I have shared my screen here, and I am sure the presentation which I shared yesterday is visible. Okay, in case of any issue, you can let me know. So in that case, afterwards we included that what are the important parameters, what are the important provisions which was available with respect of this case. So this is the discussion. I am sure there is no question till this particular time. What is provided by 31A and 31B is very much relevant. Being a law student, you can always read the particular points in order to understand the legal language properly. And I'm sure it is very easy to understand when you have already started reading certain kind of the legal provisions also. Now, what was the significance of Article 31A and B? Little bit I have put here. I have developed this presentation. It has nearly 100 slides, and all slides are including certain important developments. I will share this with you, and whenever you are comfortably able to revise, you can always refer that point so that it will give you opportunity. But considering the time limit, I will touch the important portions from that also, with your kind consent and consideration, so that we can touch the important aspect. So when Article 31A came, here we are keeping in mind Article 31 is already there. Apart from that, 31A and B is coming. So now it is superseding the orders of the court and actions. So because of that, the different kind of the activities or different kind of the acts which may be passed by the different state government become very smooth. Like in case state government want to fix the agricultural ceiling, it become very, very important. You must be knowing about the ceiling, that how much property a person can own. I explained a little bit on this yesterday also. This ceiling limit is always coming as a questionable about right to property, that how come you can fix the limit. But when agricultural holdings are there, government also got the immunized power that yes, this limit can also be fixed. When government want to put a village panchayat development, and when the planning is required to be given to village for administration at the grassroots level, and this kind of legislations also got protection, because then you are putting it away from the judicial review. And consolidation of the fragmentation of the holding, there is a law like a consolidation of the fragmentation of the holding set. Now what is happening here, you must be knowing that when the property is inherited by grandfather, then father, then with the development, the property get divided into various portions. Unfortunately, this is the situation in our country in every part. You can visit any part of the country where the once upon a time when joint cultivation might have taken place before 2-3 decades, now instead of that joint big farm, you will find out the small areas of the farm. Now it's very common sense that when you have the small farm holding, it becomes uneconomic. You can't meet with the income expenditure ratio. Means you have to spend more on seeds, fertilizers, tractors, etc. in order to cultivate the farm. And when the outcome is there, it is very less. And because of that, it become unproductive activity. Result that because of that, the unproductive areas will get increased, and government want to forcefully stop them. There is a requirement of law that they can prohibit people. Now, see, there is two things. Number one, you cannot directly restrict person to sell the property. Right to dispose is also one of the important element when you talk about right to property. But here, this is a restriction on usage also. So you don't want people to dispose, rather than you want to get the property merged and jointly connected. For that, different state governments came out with the law for consolidation of consolidation of the holdings and prevention and fragmentation also. So this all legislation which are directly affecting right to property become very properly and smoothly came in operation. And there are plethora of legislation like that. I asked the question yesterday that you are learning and going to learn the land legislation in the next semesters. Please pay attention to those laws very clearly, because I can tell you, your first, when you will start practice, and even though you are going in corporate field also, the land is becoming very important element, because whenever corporate houses will come into existence, whenever they want to develop any infrastructure, first question is coming about the land title clearance. And at the time, an advocate have to learn how to understand the ownership sequence. And for that, there is a separate legislations available. So we cannot undermine the importance of the right to property as well as the land laws also. So I cannot speak more because we are sticking to the right to property. But yes, I can always motivate and inspire you that whenever these land laws are offered to you, read those all very carefully, because when you are issuing title certificate as an advocate, you need to have a common understanding, and you have to write down that yes, based on my findings, there is no bar, this property can be smoothly transferred. So this is what happened. So this all things have been available. Now there was development apart from that, Article 31A and B, where the land relating legislations were passed. Other inclusions were acquisition by the state of any estate. You must be knowing earlier there was an estate duty. Right now we are paying taxation, income tax, direct, indirect taxes. Once upon a time, estate duty was also there. You need to pay amount of tax in case you are holding a huge amount of assets, and then estate duty was supposed to be paid. So these assets or estates, if government want to take into their possession, that road also got open in case the particular factory or any industry is not working properly. And if government want to take over the management of those industries, this is connected with the labor legislation. Then also this kind of acts came into existence, because now you can always prepare the law, you can put it under Schedule 9, you can take benefit that now this is far out of the judicial review. So you can't do that. Similarly, amalgamation, in case government want to amalgamate and 2 or 3 corporation, that thing also came into picture. In case if there is a requirement of extinguishment or modification of any kind of the corporations, or any voting rights of shareholders, and any kind of extinguishment or modification of any lease or any agreement. In short, all these activities came under the preview, because whenever the government is willing to make a law, they will always going to do that. So this all things become very routine, and it started. Now, again, one more interesting thing, we started wrestling kind of situation where the answer of the judiciary was given by the parliament. Now again, there is an open, judicial review is still open. So this entire first constitutional amendment was challenged in case of Shankari Prasad. Shankari Prasad is the second interesting judgment, which I am emphasizing, and I'm insisting that every one of you must read. Now, what is significance of this judgment? Because in this case, rather than challenging the articles, you are challenging the action of the parliament itself. So, because this is the unique thing, just in 1950, Constitution of India has been implemented. People have started following the directives. People have started enjoying the rights granted by the Constitution. And on the very first year, the Parliament has used the power and constitutional amendment has taken place. Now, in case you are a good observer, you will find that this year is very interesting. Do you know the interesting part of this year? This is the year 1951, where the original Parliament is not yet constituted. You must be knowing that there is a mandate that how government will form. There is an election required, and elections are yet to be taken into consideration. Elections have not taken place, and that is why a very, very valid question was asked by the petitioner here, that how come without having a proper elected body, government or parliament can amend the constitution? So one interesting question is rising here, that how because in Article 368, in case it is yet to be discussed, Article 368 is a all provision relating to amendment to Indian Constitution. Now that has been given to Parliament. Today also we are thinking, or we are always questioning the Parliament's power, what is the actual majority in the Parliament, etc. Imagine that so many years back, how the question would be there. So this is the first important point. That's why I told you can observe. So now in this case, the main argument was this, and this is you must also know that the main argument in the case is that entire notion or entire movement of amendment of constitution is done by the provisional parliament. So what is provisional parliament? It's a in charge, when there is no authority available, you are given a in charge role. And that's why till the time new parliament is taking place after election, who are representatives of the people, this body is supposed to work. Now, there is again very interesting calculation that original Constitutional Assembly become the provisional parliament. There were members in the Constitutional Assembly who actually sat together and enacted the Constitution of India. When it came into force, they also acted as a provisional parliament. And that's why one of the interesting argument is that how come a provisional parliament is competent to make any amendment into Constitution. Number two, and very interesting, yes, parliament has taken action in order to curtail right to property by amending the constitution, but Article 13 is still unavailable. And Article 13, I'm sure all of you might have read, it is talking about the law. pre-constitutional law, post-constitutional law, what is meaning of law. These are the three important part of the Article 13. And that's why you see what is stated in post-constitutional law, that the state shall not take away or abridge any right which has been guaranteed by this part. That has also been mentioned. So this is also a wonderful argument, that how come a right which has been identified in the beginning of the fundamental right, that's in Article 13, that law cannot be made which takes away fundamental right, and Parliament has created that kind of schedule which is giving blanket immunity. So that move is absolutely violent. And again, in Article 132 and 136, there is a requirement that the amendment is required to be ratified, which is also not followed. So this was the basic argument which was made in case of this particular Shankari Prasad case. Finally, the Supreme Court observed this. Now, this observation is very interesting. Now, I have highlighted the important portion only, otherwise the entire judgment is something very fabulous. And I again yesterday told you that when you want to understand, you read the writ petition content, it will help you that how a lawyer is actually drafting the argument and presenting in front of the court, which will definitely open new good horizon for your future practice. Similarly, some of the judgments are also very interesting. Generally, we read summary of the judgment. Right now, with the blessings of a lot of publications and publishers, crisp summaries are always available. But still, the summaries are important when you are preparing for examination, when you want to quickly view that. But best practice and best method is that you try to read the entire judgment, and if not entire judgment, operative part of the judgment. Take the original text. Right now, once upon a time, it was very difficult that you had to go to the library and take the entire judgment copy and taking a photocopy of that. But right now, even online softwares are available in which you can always get the judgment. Read this operative part of the judgment, both Kameshwar Singh case, Shankari Prasad case, and two more judgment which I will refer. Wonderful knowledge you will be able to get it. Now here, what is observation? The important part is mentioned here, that the power to amend the constitution under Article 368 is also including power to amend the fundamental rights. Okay, so generally amendment in constitution, again there is a dispute because we'll discuss Minerva Mill case. Just wait for a few more minutes. That in that case, again one particular Article 360, 368, 4 and 5 came into question. So what is the role of Parliament? They came, and that's why this highlighted word, ordinary law made in exercise of the legislative power, and it does not include constitutional amendment which are made in exercise of the constituent power. And therefore, the Shankari Prasad judgment upheld the power of the Parliament, and that's the operative part. That constitutional amendment is not an ordinary law; it is a special power. So this judgment is important because of the reason that it is making bifurcation, that general law, and I'm sure all of us are aware that how laws are made. When any you can see recently the Consumer Protection Act came in the 2019. Then the amendment took place in quite a few. Even recently, Electricity Act amendment you might have heard. So these are the ordinary laws which are specifically targeting any particular subject, and they are enacted by the Constitution. So for that, there's a process that you are presenting a bill in any of the house, then you are getting the confirmation, ratification by the members. If it is passed by the majority, then you are sending it for the president's assent, and then it is becoming in gazetted, it's published, and then it becomes the law. So this is the ordinary law. In Article 13, whatever law has been explained, it's ordinary law. So it has nothing to do with the constitutional power. And that is why the constitutional amendments shall be held to be valid. Now, let me tell you one interesting thing. This judgment again got overruled in some of the other aspects. But final conclusion is this only. In case any one of you have read the Kesvananda and Bharti judgment, or you know about the Kesvananda and Bharti judgment, the same thing is coming once again by the interpretation. And that's why this was the observation that the power of the Parliament is completely valid. Now, afterwards, quite a few years passed because this incident happened in the year 1951, where the amendment challenging, upholding the validity activity got over. Afterwards, there is a series of other judgments, but in order to save the time, I have directly brought your attention to 1967. So let's do the time traveling from 1951 to 1967. In between, almost all state governments came in full operation. They started enactment of this kind of law, gave the formulas, and these all formulas were giving certain amount of compensation to the people, and then they were taking the property from the people. Now, this is the judgment. I think the original, some of the words would be cutting here because this, I think, Zoom window is visible. The case is IC Golaknath versus State of Punjab. This is the citation. I'm sure all of you might have heard about the name IC Golaknath case. Golaknath judgment is wonderful because it has also contributed a very wonderful doctrine. And let me tell you one interesting thing. This judgment is also known Operation Successful, patient died. This judgment is also known. Operation is successful, patient died. Now, why I am telling you this, just wait for a few more minutes and you will understand. So this is this judgment is having a long series of the facts, because total 5 different activities were challenged. Out of that, the main activity or main contention is this. There was a family, Golaknath family, and there were owning 500 acre of the farmland in Jalandhar in Punjab. It's a very huge area of the land, and you must be knowing that when you inherit the estate, being the successor of the king or emperor or princely states, you will always have a huge area of the land. In order to curtail the rights of the owner, this law came, Punjab Security of the Tenors, Land Tenors Act 1953. Today, when we are a new generation in 2021, this kind of laws are not visible on a very large scale. You know, sometimes it happens. It happened with me also when I was learning about the law in the year 2004-5. That how these different laws are coming, what is connection? In case the Punjab word has been used, have you heard about the PEPSU? PEPSU, PEPSU. When you read the Constitution of Indian judgments, lot many times the PEPSU is also, the Punjab and Patiala, that was a particular word, the PEPSU. So there was a Punjab and Patiala state union. That was an identification before the submerge of this particular state. Later on, that state got eliminated and the boundaries got mixed with the Punjab, Haryana, and some other part of the country also. But still in citation, this PEPSU word is always coming. So students keep asking that how this particular thing happened, but that has connection with the old. So in case you get any confusion about the name of this particular territory, you can always see that what was the original territory of the princely state. You will understand that for some time, this particular states was given power. Later on, when they merged with the Union of India, that boundaries got abolished and then they took a new form of the state, which is available right now. So this law was passed, and what was the main purpose of the law? That owner of any land, this is again like a ceiling legislation, that you can take only 30 acre of land with you, remaining acre will be given to tenants, and remaining land, if there is no tenant, will be declared as a surplus land. Surplus land is also called Khalsa land, and government will take the land from you. So this is called ceiling limit legislation. Now, primarily, it's completely, it's something which is very bad, that how come out of 500 acre of land, you tell government that, okay, you can keep only 30 acre, means less than 10% land I can own. And whenever you own property, this move will always be opposed. And that is why in IC Golaknath case, brothers, the family Golaknath brothers decided, we will challenge this. And what they challenge, not only this, but apart from the legislation, they challenge the other moves also. So they challenge the constitutional amendment. They challenge the 17th constitutional amendment also, which was placing the Punjab Security of the Tenor Act in Schedule 9. And also they challenge the right to property under Article 19 and 14 both. That the particular calculation is completely discriminating how you are deciding, in what criteria you are deciding. Because right now, I am sure you have reasonable understanding that under Article 14, I always ask a question. Do you think that Article 14 is absolute equality? It's not absolute equality. It's a equality amongst equal, right? I'm sure you might have it's equality amongst equal. Means even though you want, you can make a discrimination, you can make a classification, but that classification must have to have a reasonable justification. And that thing is visible again here. When you will read this IC Golaknath judgment, they are very beautifully arguing that on what basis 30 acre of land you are allotting. Do you have any kind of calculations or do you have any kind of the proof in which you are concluding that in case I have 30 acre of land and if I cultivate, it's a reasonably good, income expenditure ratio I can able to meet. So it was challenged. So the first constitutional amendment, the right to property aspect, right to freedom of property as well as equality, as well as the constitutional amendment was challenged. And this was the one of the issue before the court, whether constitutional amendment is law under Article 13(2) or not, and can fundamental right be amended or not. So these two issues again came in front of the court when the court was supposed to answer. These two are very interesting, and pages have been available with respect of these two issues only. That whether, and I'm sure that you are aware about the issues also. Whenever any matter is brought before the court will frame out that what are the basic contention, what are the basic issues. So these are the two issues. Now let's see how the answer has been given. This is the judgment of 11 judges bench, and that's why they struck down the particular decisions. So Sajjan Singh and Shankari Prasad judgment, whatever view was taken, it was struck down. So now what is the observation in Shankari Prasad case? I highlight once again that the constitutional amendment is not an ordinary law. It is something done by virtue of the constituent power. And that is why it will be considered to be the valid, even though it is violating fundamental right. Now this was overruled. So you can always note down, you can make a sequence, Kameshwar Singh case, and ultimately the judgment in rest of the Shankari Prasad case, it is overruled by the IC Golaknath case also. Now, what are the important observation of the judgment? I would willing to bring the good text of the judgment, but yesterday is my experience that when we discuss too many things, 1 o'clock is approaching very fast and you don't get time to discuss more. And that's why I have put the selected quotes also. And believe me, this quote I am showing you right now, which were part of the judgment in the year 1967, it is still relevant in 2021 also. Just wait for a few more minutes and you will understand what the honorable judges held at the time and how you can connect. This is what a very important observation, that constitutional amendment is law and it is falling under meaning of Article 13 itself. And that's why, contrary to what has been stated in Shankari Prasad case, if it is taking away the fundamental right, they can be considered to be the invalid. So you cannot make any. So the judgment is very clear that in case you are making an ordinary law or constitutional amendment, both will be considered to be law. And that is why it should not take away any of the fundamental right guaranteed by Part 3 of the Indian Constitution. Now there is a logic. How come court come to this conclusion? Do you want to say that earlier judges were not using their power or they were not applying their mind properly? Do you want to say this? Answer is available in the particular some of the quotation. And that's why this judgment is called Doctrine of the Prospective Overruling. Now, what is prospective overruling? Let me tell you, the courts came to this conclusion very clearly that the parliament shall not have any kind of the right to amend the Constitution of India in a way your fundamental rights will be violated. But this judgment shall be operative from today itself. Means whatever has been done earlier, that's nothing to be considered here. Generally, courts are giving two kind of judgment. Number one, what has been done earlier, you have to rectify that. So governments are given instruction that, okay, you have not paid the compensation, pay them with the retrospective date. You have taken possession, restore the possession. So this kind of judgments are also available. But here, contrary to this kind of situation, the judgment is talking about the prospective aspect. So from the date of the judgment, that is the 27th February 1967, Parliament shall not have any power. Means whatever has been done till today, we accept, let it be. But now onwards, you shall not amend any kind of the constitutional provision which will violate fundamental right. And that's why it is known as a doctrine of the prospective overruling. And that's the reason I told you operation successful, patient died. Means the petition which was filed before the court of law resulted into positive. Yes, this is something wonderful that court accepted the contention. But this benefit will not be available to you. For you, whatever has been done, we accept. Next, your judgment will be operating for the another people. So this is the important part of the judgment. I'm sure it is getting clarity and you are getting it. In case the speed is high, you can let me know. I can slow down a little bit in case you are having any problem. Okay. So this is the point. Now, why this doctrine? Students always keep asking the question that, sir, what is the reason? What is the justification? Why court didn't accepted that the activity of the government which took place with the Henry brothers was also not valid? This is the reason available. See, there is always the reasonable justification. In future, you will happen to study the judicial process. I don't know whether in UG level it will not come, but yes, in case you are going for higher studies in PG, judicial process is taught. So when you talk about the judicial process, you bifurcate. It's a judicial review, judicial activism, and judicial self-restraint. These three are very popular, words, very popular, and you will find series of articles on that. Judicial activism, MC Mehta judgment, and the series of judgment which came in environmental jurisprudence. Judicial activism. There is no law. Court came out with the law. This is judicial review, in which the previous court judgment or the lower court judgment is going to be reviewed by the court. That's a case of the judicial review. But third is judicial self-restraint, in which judges always apply their mind and think that, yes, even though we have power, but we have to see that our judgment should not result into chaos, anarchy into my society, and situation will come when people will go and will not trust the government also. Now imagine, during 1950 to 1967, I told you that after the judgment of the Shankari Prasad, so many legislations came in existence which were talking about the agrarian reform. And most of the agrarian reforms were mandated, advisable, and it was high time that government should take action. Because in case government is failing, then it will be a very bad impression. And that is why if Supreme Court restrict in the year 1967 that whatever, because it is not possible that you can take shelter of only one law, that okay, the Punjab Security of the Tenure Act, which was passed in the 1953, is unconstitutional, but other acts are constitutional. This kind of bifurcation cannot be there. You have to declare everything as unconstitutional in case you want. And that's why in case all the activities are restricted, it would result into chaos, unsettlement in the country, which a new independent country cannot afford. And please keep in mind, this is also time where two of the wars are already fought, one with Pakistan, one with China. And in case you are aware, the Indian situation, political situation after the war with China, you will be able to understand. Just 2 years back, in 1965 also the war has taken place. So sometime we always keep asking that, sir, why judgment? So generally, that's what I told yesterday. That don't read always judicial proceedings or judgments in isolation. Understand that what is the political situation of the country and whether judges have taken a stand properly or not, that commentary is available. But the date of the judgment along with the political situation, when you mix both of them together, you will find out that yes, the reasonability is asked by the government. That recently, when government is not able to pay, because otherwise what happened? Whatever amount of compensation is paid by government, either they have to increase or the amount is required to be deposited once again. Huge amount of monetary cost will also be there when the laws are repealed or it will come to the conclusion. And that's why this particular thing came into picture. Now, the observation by Chief Justice in this case, Justice Subba Rao, is very interesting. I like it very much, and I don't know how many of you read those earlier, but I want you to just have a look to that. Fundamental right should be looked upon from the point of view of any particular difficulty of the moment, but as something that you want to make permanent in the Constitution. The power matter should be looked upon, the other matter should be looked upon, however important it might be, not from this permanent and fundamental point of view, but from the more temporary point of view. So there is observation that fundamental right cannot be compromised. It's something wonderful. So in future, if you're writing any article on fundamental right, you can always give this quote from the judgment of the IC Golaknath, that what's the significance of the fundamental right is something very permanent. And that's the reason there is a bifurcation between fundamental right and directive principles of the state policy. Okay, there is one more observation. Pandit Jawaharlal Nehru, who was the prime minister at the time, who must have had an effective voice in the framing of the Constitution, made this distinction between the fundamental right and other principles or other provisions of the Indian Constitution, namely the former are permanent and later were amendable. So it is always expected that when the government enacted the fundamental right and put along with the two important articles, Article 12 and 13, it is with the intention to make a permanent. So there should not be any kind of changes. There should not be any alteration with this particular very important notion with the particular fundamental right. Now, Justice Hidayatullah also gave opinion, and this is something very interesting part. That there was a strong opposition on unlimited power of Parliament to amend the Constitution. Whether Parliament reserve unlimited power to amend the Constitution or not, aren't we doing this discussion today also? When after 2014, we observe that majority of the government came, and that again, right now the current UPA government, NDA government came into operation and they got repeated. This question is still asked. You read this good learned people's articles or scholars' article. They also have the same kind of opinion that when government has power, is it very comfortable situation or it's very danger? And that's what Justice Hidayatullah at the time has observed this. I have highlighted that they warn about the danger of the majority party in power because it will go beyond the constitutional limitation to get a power. Hence, the Parliament has no power to amend the fundamental right. So in case government is getting majority, they can do with the other part of the Constitution, but fundamental right should not be there. And this is the selected quote from Justice Hidayatullah's judgment. See what is mentioned. I do not for a moment suggest that the question about reasonableness, expediency, and desirability of the amendments of the Constitution from a political angle is to be considered by the court. However, what I say is that the possession of this necessary majority does not put any party above the constitutional limitation implicit in the Constitution. So just by majority, Bharti or any government cannot think they are beyond. And this is the important final conclusion. It is obvious that the Constitutional Assembly, in making the fundamental right justiciable, was not justified with the reliance on the sense of the self-restraint or public opinion, as the majority of the Sajjan Singh case does. This is not an argument of fear. The question to be asked is, can a party which enjoys two-thirds majority today, before it loses it, amend Article 368 in a way that the simple majority would be sufficient for the future amendments of the Constitution? Suppose it does so, would there be any difference between the constitutional and ordinary law made thereafter? That's a wonderful quote. Are you getting? So today I told you that the judgment which was passed in the 1967, today also you have seen that when government comes into majority and some actions taken by government always are viewed. So these are the something which is very evergreen discussion, which can be quoted in not only with right to property, but also with the government's power, parliamentary provisions, fundamental, the judicial observation, etc. So this quote you can also keep in mind whenever is available. So finally, coming to the conclusion that the IC Golabnath judgment was again very strict, that government have not any power from the date of judgment. But do you think that the government's power can be curtailed? See the reaction. Again, I told you about wrestling. So the moment IC Golabnath judgment came, Parliament also again exercised the power. And then 24th Amendment came. Now, this is very interesting. In case you have a barrack of the Constitution of India with you, just keep it open and you read Article 13.4. The same year, when the 24th Amendment came in the year 1971, two very interesting addition came. Article 13.4 added, and the same thing was made in Article 368.1 also. So today, two articles are available. Article 13.4, the same kind of thing is available in 368 also, that nothing in this article shall be applicable to the amendments made into the Constitution. So Article 13.4 included that this article shall not apply to any amendment of the Constitution under 368. So means the IC Golabnath judgment observed that constitutional amendment is also law. Now this Article 13.4 is doing away with that. That no, whatever I stated, now we are amending that the constitutional amendment shall not be considered to be the law, and that's why it shall not be applicable. And same in amendment was made in 368, and it was observed that the Article 368.1 in exercise of constitutional power. So the title got enacted that whatever has been done in exercise of the constitutional power, it will not be applicable to the amendment. And Article 368.3, the same wordings you will find out comparing to Article 13.4. So Article 368.3 and 13.4, if you see both articles, this word have been available. This nothing in this Article 13 shall apply to any amendment made under this article. So now when you read this both article, try to understand the just reason behind that. Generally, it happens that we study constitution in a piecemeal. That okay, first understand fundamental rights, then go for 368. So till the time I think in Constitution 2, when you reach to 368.3, I think previous part might have been forgotten. This is a good opportunity that you can understand both the provision, and I'm sure now you will not forget why this thing has been done. Okay, and it has great connection with the right to property. So I'm sure it is getting clear. Afterwards, 24th Amendment came, 25th Amendment also came, and this amendment added some more features. Now see this interesting part. Article 31 got amended because Article 31 I have already highlighted yesterday. The 6 sub-clauses talking about the public purpose, talking about the compensation, talking about the right when the power has been exercised. Now here one amendment was brought again in 31, that the amount which has been fixed under acquisition cannot be challenged in court of law for adequacy. So now you cannot go into court of law under 31 also in case amount is inadequate. Plus there was Article 31A, 31C came. And what is 31C? That in case government has enacted any of the law in order to secure any of the directive principles of the state policy, then also it should not be held to be valid if it is violating Article 14 and 19. Now posing for the moment, you must have remembered read the list of directive principle. In case you have barrack, you keep it open and you see there's a concept of the social security, there is a concept about the maternity benefits, there is a concept about the equal pay for equal work, and so many directives are available, including uniform civil code, right? So all the directive principles where the government is making law, and if because of the mandate government has made a law, and if it takes away Article 14 or 19, then also you can't challenge that. article has been added, Article 31C. So this is again one interesting amendment, and this was in order to supersede the Golaknath judgment. Now you see what Parliament will do now. Article IC Golaknath judgment tried to be superseded by 24th Amendment, 25th Amendment. Now you see what is happening, that this resulted into Kesvananda Bharti versus State of Kerala, the landmark judgment and a very important judgment for today and in next few cases also. So the situation become very important because this activity took place in the year 1971, 1972, and based on that, again Parliament achieved the power which was taken away by the Supreme Court by the judgment of IC Golaknath. Now here what happened, the IC Golaknath matter was from the Punjab. Now this matter was from the state of Kerala. You must be knowing that in India there is a tradition and there is a concept of the Deva Dravya and donation and charity. I'm sure you might have seen there are so many temples in which people worship the god and they donate the property, they donate the land also. And land donation was something very popular activity in so many years back. When the kings were there, they were officially giving the land to the particular states, particular temples, and they were making the law that the temple will also nurture the cow, animal husbandry, and the land will belonging to the particular temple. Here, His Holiness Kesvananda Bharti, he was a Hindu mutt in Indira village, and here the effort started. Government made out the law, which was in the same line that the particular restrictions will be there on the management. So management of this particular thing will be taken away. Just give me 1 minute. Okay. So there was a case, or there is a particular activity that there is a restriction on the property management, and the senior head of this particular Andir Mutt challenged that this activity or this particular restriction which are imposed on that property is completely not justifiable. Now we have seen that these laws are challenged under Article 19 and 14, but Kesvananda Bharti case is very interesting because one more article is added here, and that is relating to right to religion, and this matter fall under Article 26. Now again, fundamental right, Article 26, you might have referred, Article 25, 26, 27 and 28. This couple of articles talks about the fundamental right of religion, and it also includes right to manage the religiously owned property without government intervention. And that's why the matter went that as this is a temple property, it is a property of the Hindu mutt, you cannot restrict any kind of management restriction on that. So the action of the government is completely void. Apart from that, there are other previous amendments, 24, 25th and 22nd and 29 amendment also got challenged, which were added in order to supersede. So now this petition also got again gave opportunity to the Supreme Court of India, that now let us see once again what is right to property justification. Now this is the list of judges, the highlighted judges, majority judge, minority judgment is also there, but these highlighted judges they are very popular in some other matters also. More particularly, the election matters came into picture. Justice Ray, Justice Grover, Justice Shalat, Justice Hegde also. And Justice Chandrachud name is also very popular when you might have heard about ADM Jabalpur case, habeas corpus case, something wonderful about the personal freedom. And recently when the Justice Chandrachud, right now sitting judge of Supreme Court of India, also gave wonderful opinion with respect to the similar matter. So this name of the judges are also very much important in order to say. Now here, what is observation as time is approaching, we'll cut short the discussion. And it was held that number one, the Article 13.4 is valid. So Article 13.4, which is making a provision that this shall not be applicable to any kind of the right to any of the amendment, it's fine. And that's why the fundamental right can also be amended under 368, and validity cannot be questioned on the ground that the act invites encroachment of the fundamental right. So this judgment is final version, that in case there is a normal law, you can always challenge to be unconstitutional, and you can challenge before the High Court, Supreme Court by virtue of the writ petition. But if it's the constitutional amendment, it shall be valid and it shall even though it is taking fundamental right, there cannot be question. But with this particular judgment, the court tried to make a permanent situation, and that is something a basic structure doctrine. This is a very popular doctrine and very famous among the law students also. So I don't think it is a requirement to elaborate the doctrine in detail. But yes, I will highlight one interesting thing which might not have come into your discussion in a previous point. What is actually the basic doctrine? So the conclusion of this Keshavan and Bharti judgment, there are a lot of, and believe me that Keshavan and Bharti judgment, 13 judges judgment is equal to one full book. So when you read the judgment, it's equal to size of the average book, which you can refer it. And there are law students who have passion to read the judgment also. Even I, before discussing the topic land law, I happened to read, it took nearly 6 months for me to complete the entire judgment, but it was wonderful. The operative part of the judgment, observation of the judges, and wonderful commentary. Like I highlighted some of the selected quotes from the IC Golaknath, same quotes you will find out this judgment also. So in case it's possible for you, try to read this judgment. You can take 1 or 2 months or 6 months also, no problem. But by the time you will be graduating, you will be able to have a good thing that yes, I have read the Keshavan and Bharti judgment in a detail. So crux is like this, that basic structure doctrine was given, and it was held that Parliament have unlimited power to amend the constitution. This constitution amendment shall not be considered to be the law, so it shall be considered to be the valid. It may affect the fundamental rights also, but it should not disturb the basic structure of the constitution. And what is basic structure? That has been elaborated by different judges in a different way, which I want to highlight for you. Okay, so different judges, including Justice Sikri, Justice Shalat and Justice Grover, Justice Hegde, Justice Mukherjee, and Justice Jagan Mohan Reddy. Now, these judges have given very clearly that this is what basic structure according to us. Today also, if you ask what is basic structure, so then multiple answers will be available. Read this judgment, and at least this part, you will be crystal clear that what actually is held to be a basic structure, and it is taken on a very wider sense by the advocates whenever they argue. So quickly see what is basic structure as per Justice Sikri: supremacy of the constitution, republican democratic form of government, secular character, separation of powers, and federal character. So this is a basic structure you can't disturb by constitutional amendment. Justice Shelat and Justice Grover emphasis on the welfare state. So welfare state and directive principle and unity and integrity of the nation is basic structure, cannot be compromised. Number 3, Justice Hegde and Mukherjee highlighted the sovereignty of India, democratic character of the polity, unity of the country, essential feature of the individual freedom, and mandate to build a welfare state is basic structure. And finally, Justice Jagan Mohan Reddy, sovereign democratic republic, parliamentary democracy, and 3 organs of the state. So in a nutshell, all these basic structure are considered to be the very important when the constitutional democratic government is there in our country. So you can't do rest of the things, you can always do that. Finally, later on, there are certain important development. 2 cases are there, Minerva Mills case as well as the Indira Gandhi versus Narayan. But after the Keshavan and Bharti case, 2 development have happened. I will take 5 minutes maximum and will conclude the discussion by that. So again, after Keshavan and Bharti judgment, Indira Gandhi government also made certain changes, and this changes was amending the Article 31A, 31D. So these 2 things came, that obligations to pay compensation were also excluded by virtue of that. So Article 31D has been repealed later on, which took place, and Article 31A, B, and C again when it happened gave a blanket cover. And this is something important, that from the year 1951 till 2000, there are 284 laws added into Schedule 9. And yes, it is also criticized that a lot of laws are not. Article 31B originally was created by virtue of right to property. That right to property and government has right to manage. This law should not be touched. But later on, you will find out the law not relating to land laws also. So like, the MISA Act, TADA and POTA Act, which are relating to anti-terrorist activity, and some of the management relating to the establishment, these laws also came into picture. So this all development has taken place. That's a separate story behind that also. So a lot of changes came in Indira Gandhi versus Narayan case is important because Article 329A, 4 and 5 election matters were also kept outside of the judicial review. That challenge, but again it was finally added. But finally, the last point is this, that when even after this judgment by Keshavan and Bharti, when it was observed that Parliament is constantly making amendments, first time when Janta government came, because after emergency, the situation in the country was little bit very different for the old government, this Indira Gandhi government. And that's why first time Janta government came. They made a first activity, and that activity is known as a death blow to right to property. Death blow word has been used because right to property was removed from the fundamental right. Till this time, Article 19(1)(f) was there. So you can officially go to the court because fundamental right was there. Yeah, you can challenge the compensation, you can challenge the activity of the government, but fundamental right was granted. This was completely removed. So Article 44th Amendment again made lot of changes in order to supersede the 42nd Amendment. There is no time to discuss all other amendment, but yes, right to property things will consider. So Article 19(1)(f) was repealed. Article 31 was also taken out of Part 3, and Article 308 took place. So now you can see Article 308. So this is the entire discussion in nutshell which we made. So where right to property can always be studied in light of this pre 44th Amendment, post 44th Amendment, Article 31A, B, C for 13(4) and 368 1 to 5. This is development of the post pre 44th Amendment. After 44th Amendment, this has happened. So 19(1)(f) omitted, 31A inserted. You must be knowing what is 31A. This is right of minority educational institution to get a compensation as per the market value. So read Article 31A, that is, in case government is acquiring the property of the minority education institution, then the compensation should not be less than the amount which will give opportunity to that institution to be relocated at a similar kind of place. So it is officially market value. So that is fundamental right which has been inserted. So minority education institution got protected. Article 31 omitted, 31D was omitted. But in finally, Minerva Mills case is very landmark. I will tell you to read Minerva Mills judgment. In previous case, in case of the 42nd Amendment, Article 368, 4 and 5 was also amended. That the special powers given to Parliament with respect of the procedure, with respect of the particular fundamental right. After emergency, when Minerva Mills case was filed, they struck down. So today you will find out that this has been struck down. So these two articles are there, but they have been struck down. And finally, the same discussion got repeated in the year 2007 when IR Coelho judgment came. There's a last one in the year 2007, Supreme Court, IIR 2007, Supreme Court 861. Here also the matter is belonging to the Tamil Nadu also, where Gundur, the Plantation Act was there, and it came to be included into the Article 31B. And when the court gave the judgment, they repeated everything. So in case you are unable to read all previous judgment, you read this judgment only, IR Coelho versus State of Tamil Nadu, and you will find out that all the right to property jurisprudence is very well explained. I have the copy of the judgment. I will share this with you. And finally, this judgment also upheld whatever stated in Kesvananda and Bharti case. So conclusion is this: number one, right to property is not a fundamental right. So government has all right to change, the ownership of the property, to take the property under acquisition. Yes, now it is subject to the Land Acquisition Act also, which is a separate thing. But in case government don't want to acquire the property under the Land Acquisition Act, special legislation, special acquisition, special amendment to the Constitution can be made. Number two, after the Kesvananda and Bharti judgment, all the acts which are part of the Schedule 9 shall not enjoy automatic blanket immunity. So now this judgment reiterated that even though the act is in Schedule 9, that is Article 31B, it will be open for judicial review. So in case judiciary want to review that particular case or act, they can review. In case it is taking away fundamental right or basic structure disturbance, judiciary has got the right of struck it down. And number three, and very important, right to property is now as a constitutional right, and that's why the fundamental right provisions is not available. Mean enforcement by virtue of the writ petition going to the court, is Supreme Court of India, is not available. But yes, it's a constitutional right. So the compensation and reasonable amount of, the amount of compensation shall be paid. So this is how the entire discussion on right to property can be there. So this was the little bit discussion which I wanted to make with respect of the exhaustive part. I told you, I'm again very sorry I had to move a little bit faster because a lot of things are required to be covered. And when you have it, because I will tell you, when I was discussing land and agriculture law with my students, it took me 5 classes. That is 60 minutes of each and length. And we discuss all the things in episode, one episode for Kesvananda and Bharti, one episode for IC Kulagnath, one episode post IC Kesvananda and Bharti, there is a IR Coelho judgment. Nevertheless, I have full trust on your the academic efficiency, and I wish that the references which I am willing to share with you, you will use it in the best possible way, and this all important articles will be helpful to you whenever you want to understand about right to property. So I'm sorry it's 1:13 already, but anyway, thank you so much again. Over to you for any question, query, comment, suggestion, anything.
Thank you, sir. There are some questions.
Yes.
A question asked by Vineet Agarwal. There is a recent Supreme Court judgment wherein it was held that the right to property is not a constitutional or a statutory right, but also a human right. So what this human right add to this Article 300A?
See, I have to check which judgment you are referring. In case you are able to write down, but see, this can be interpretation, and I doubt in case recently one judgment came in which the compensation matter came. So right to property is considered to be the human right aspect, because whenever you are giving fair compensation, you are displacing people from the area, and that's why right to get rehabilitation is also there. So there are also a series of judgment in which court has reiterated that you cannot simply displace the people, you cannot simply tell them go away by paying some low token amount of consideration. In that line it is available. So in case you are able to share the citation, I would be able to give my observation and commentary on that.
Yes,
in case of adverse possession, when government take the possession of private property without procedure, what can be the action by the court? Yeah, you can always go to the court and you can file the writ petition. Adverse possession is something which is very controversial, which is not available in every case. But yes, the court will definitely issue the notice, and then the action of the government can be challenged. Yeah, you will not be able to trigger right to property notion. Means you cannot show or you cannot argue that it's my fundamental right. But yes, action of the government, procedure on which the government took action, as well as the compensation can always be asked, and government and court can always order about of the higher amount of compensation. So that is possible.
Sir, in the earlier question, there was a case named the State of Haryana versus Mukesh Kumar. That was a 2011 case. So in this case, that case was referred in the last case.
Sorry, your voice was not clearly audible. Yeah, can you repeat again some point, please?
The question which I asked about the recent case, in the same case, Supreme Court referred to its own judgment. That was the 2011 case of State of Haryana versus Mukesh Kumar.
Yes. Good. I got your point. So the same thing is there. Human right aspect is also available. But now I told you that the right to property jurisprudence has been settled. Different interpretations are there in which the petitioners are given certain kind of the favor and maximum amount of compensation. And I will tell you to read the recent law also, in which rehabilitation resettlement has also been granted. So courts take this kind of view and pass this order accordingly, subject to basis. But original discussion, which is constitutionally required, that right to property is a fundamental right or not, and what is the extent of the power, that has been satisfied by virtue of the series of this judgment, which we possibly could include in the discussion today.
Okay, sir.
Yeah. So that's it.
Yes, sir. That's it. So
thank you so much.
Can we move forward to vote of thanks?
Yes, please. I think you have another class at 1:30. Right? I'm so sorry to keep you waiting. Yeah, please let's complete it very fast. No problem.
Yeah, no, sir, no issue. I would like to call Vineet Agarwal for vote of thanks. Vineet, over to you.
Thank you, Garima. You gave us your time, the most precious gift of all. Today, my words are not enough to express the gratitude. On behalf of Department of Law, PIMR, I, Vineet Agrawal, would like to express my sincere gratitude to Dr. Hardik H. Parikh sir, who shared his knowledge with a thought-provoking address and giving us a new dimension on how to look Constitution from different aspects. I would like to thank Assistant Professor Kamlesh Jain sir for organizing today's EML and for his vision and guidance at every step. I also thank Assistant Professor Nakul Singh Chauhan sir for his support throughout the session. Heartfelt thanks to student coordinators of EML committee, Ms. Priyanshi Jain, Mr. Nishan Jain, Mr. Kshitij Rajpurohit, and other committee members, because without your cooperation and dedication, we could not have pulled the work together and made it a true success. Last but not least, I thank all the students for showing their interest in this EML. Once again, thank you very much to all who assembled here.
Thank you, sir, for sparing the time, and we hope
so
to
much.
have a continued association with you. Once we are through with the pandemic, we would love to have you in person also.
Sure,
And
sir. Thank
we
you so
also got
much.
to interact with one of your senior colleagues, Dr. Parmeshwar, and he's visited our institute
That's nice.
on
Yes.
numerous occasions. So we look forward to see you
Very
in person.
nice. You
also.
can always let me know in case you need any other subject relating discussion also. It would be my pleasure to be there. Thank you so much.
Thank you so much, sir. Thank you so much for
Thank
your
you so
time.
much, sir.
Wish you all a happy learning. All the best.
Sir,
Thank you.
I request you to please, if it is possible, to share the presentation.
Yes, yes. I will share the presentation. Should I reply in the same mail on which I got invitation?
No, sir. I'll just share my email ID here on the chat with you, so you can note it down.
In case you can send me the email ID, I would definitely share it by email.
Kshitij, if you have first contact number, if you can forward your own email ID or my email ID, it will be fine.
Sure, sir.
Yes.
Okay. Okay, that's fine.
Thank you so much.
Thank you so much, sir.
Thank you so much, sir, for your time.